We are here for oral argument in the matter of the state of Brenan Seiler, case 29756. Each party will have 15 minutes to present its arguments. Appellant may reserve up to 5 minutes for rebuttal. If you wish to do so, just let me know before you start your argument, and I will do the best I can to keep you apprised of your time. The arguments are being visually, audibly recorded. They will be posted online, and they are being live streamed right now. We have read your briefs, and we are ready to proceed when you are.
Thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal, please.
All right, thank you.
May it please the court. SUMA's claim against Mr. Seiler's estate was not contingent because contingent events do not equal contingent claims, and because for the purposes of the presentment statutes, a hospital's claim for medical services provided to its patient accrues when the services are provided. The presentment scheme is about notice. Section 2117.06 of the Ohio Revised Code provides a mandatory 6-month deadline for all creditors to present their claims against an estate for purposes of preserving the claim and putting the estate on notice. That statute expressly provides that all creditors shall present their claims whether due or not due. This is because the purpose of that statute is not for creditors to immediately litigate or collect on their claims. It's for purposes of presenting and preserving the claim to put the estate on notice of the liability. SUMA's claim in this case against Mr. Seiler is for an unpaid medical bill. The only event giving rise to that claim was the rendering of medical services to Mr. Seiler on May 12, 2018. Mr. Seiler's liability to SUMA for $341,000 existed at that time, and SUMA knew about it. SUMA had 6 months from the date of Mr. Seiler's death to present their claim against his estate. They failed to do that. Instead, SUMA pursued insurance payments from the West Reserve Employee Medical Benefit Plan, and that pursuit resulted in lengthy internal appeals and ultimately a denial of coverage. When SUMA realized that it couldn't get insurance coverage, it then went back to the probate court, opened an estate as administrator of Mr. Seiler's estate, and attempted to present an untimely creditor's claim outside the 6-month presentment period. The only way for SUMA to accomplish that was for them to argue that their claim was contingent, which is an exception under the presentment scheme, section 2117.37. SUMA's claim is not a contingent claim. That section of the statute requires that at the time of the decedent's death, the liability was uncertain and that a cause of action subsequently accrued. For example, a case of a guarantor is a true contingent claim. Suppose that Mr. Seiler was the guarantor on his brother's bank loan, and during Mr. Seiler's life, his brother makes timely payments. 8 months after Mr. Seiler dies, his brother defaults. The bank's claim against Mr. Seiler as a guarantor accrued after his death and outside the presentment period. That bank can legitimately present its claim outside the 6-month period as a true contingent claim. SUMA's claim in this case is fundamentally different than that. At the time of Mr. Seiler's death, it knew the full liability that the estate could have to pay down to the penny. It ignored a known and accrued liability to pursue insurance payments. SUMA cites this option of insurance coverage as the reason why its claim is contingent. But the presence of an insurance company and the option of insurance coverage does not change the legal accrual of a cause of action. For example, let's say that Mr. Seiler gets into a fight the night before he dies and badly injures someone. The person he injures wants to sue, but doesn't go after Mr. Seiler. Instead, they pursue his homeowner's insurance, hypothetically. He fights with the homeowner's insurance for 2 years about whether or not there's coverage. When he's denied that insurance claim, he then attempts to sue Mr. Seiler for assault outside the 1-year statutory limitations period for that claim. If that victim claims that he didn't have a claim until the final denial of insurance, that argument would not work, because an insurance company's decision has nothing to do with the legal accrual of a cause of action.
Counsel, let me ask you a question on your example. I am guessing, and I don't want to speak for opposing counsel, but I'm guessing is what he would say is, sure, that's just another example of the tort, your last example with the fight. How do you respond to that?
Yes, and I do believe that would be SUMA's response. Throughout the briefs, SUMA makes the argument that the cases we cite are about torts, and that is a distinction that the court should focus on. However, the reason that we analogize the way that we do with these cases is because there is no case on point. There is no situation where a hospital pursued insurance payments and ignored its statutory requirements under the presentment scheme. What we do with these cases that involve torts is draw an analogy, essentially, Your Honor. And that's why this case is so important, and that's likely why we're here today, because we want to reaffirm that the presentment scheme applies to hospitals as it does all creditors, and that the statutory language is plain and unambiguous. They didn't intend or write in any exception for medical providers with the option of insurance, and we believe that these cases are analogous and provide guidance for the issue before this court.
Thank you.
And the point of my example, again, to reiterate, is that the trial court found that SUMA's claim did not and could not legally accrue until the insurance company made its final denial of insurance coverage. If this court affirms that ruling, then insurance company decisions could dictate when a statutory limitations period begins to run. And the legislature did not intend for that to happen in the context of the presentment schemes. The legislator actually intended that the presentment requirements be strictly applied. And Ohio courts have done that consistently. If you look to the Markham case, which actually is what I cited at the beginning when I said contingent events do not equate to a contingent claim. That court was presented with an argument from a creditor who was waiting on certain questions of proximate cause, damages, and insurance coverage that he felt had to be resolved before he had a claim against the estate. And the court disagreed with that point, stating that contingent events, like an unknown amount in the case of SUMA's argument, or unknown questions of damages, do not make the claim contingent. And again, that's because the overall reason for the statute is to put the estate on notice of the liability and not to actually litigate a cause of action. The Brenan case is another one of the tort. Yes, Your Honor.
I have a question for you. What if, this is a hypothetical, but say while Mr. Seiler was passing away in the hospital, there was a civil case pending against him, and it had gotten to a decision, but there had been no damage, and not a criminal case, but a civil case. The amount hadn't been determined yet, but there'd been a judgment against him.
Mm-hmm.
What would happen at that point?
As far as the presenting it against the estate?
Yeah, I mean, I presume that the estate would have to be opened and that a claim would have to be made against the estate, but we don't know the amount yet, right? Because it hadn't been determined in the civil case.
Right.
Well, how would that proceed?
Well, to one of your points, the estate doesn't actually have to be open. Subsection B of the presentment scheme puts the onus on the creditor, even if there is no estate opened and even if there is no administrator, they still have to present that claim to the probate officer. And to answer your question about the amount missing, Ohio courts have established that if the liability exists, which in your scenario, I would argue that it does because there's been a judgment, that creditor or the holder of that judgment is required to present that claim and to let the estate know about that liability. The 6-month time period that creditors have to present their claims is not the beginning and end of the claim. So it's the time period that they have to present it, but the claims are not litigated or necessarily collected in that 6-month period. They're merely preserved. In this case, because SUMA knew the full amount of the liability, they present and preserve that full $341,000 amount. And then if they also pursue insurance and there is some and the estate ends up owing less or none, that's great. But in order to get payment at any point from the estate, it would have to be a preserved claim during that time period. I want to also touch on one point that both the trial court and SUMA made in describing their claim. They described their claim as not yet ripe for presentment. And first, to that point, I want to say that that phrase is found nowhere in the statute or any of the cases that have applied these requirements. And we likened SUMA's claim to an unmatured claim in our briefs and before the trial court, which means that when the liability is certain, but the due date or maturity has not arrived. And we likened it to an unmatured claim as opposed to what they argue as a contingent claim.
Counsel, I just want to let you know you're getting into your rebuttal time now. You're welcome to keep going. I just want to keep you apprised of time.
Oh, I will wrap up. To that point, SUMA insisted that their claim was not yet ripe for presentment. And my only point is that's the same as unmatured. It's another way to say that our claim is not yet due. And the statute requires that even unmatured claims be presented within the 6-month period. So in summary, we request that this court reverse the trial court's decision because SUMA's claim was not contingent under the statute. And if there are no additional questions at this time, I will reserve the rest of my time for rebuttal. Thank you.
All right, counsel, whenever you're ready.
Thank you, Your Honor. Good morning, and may it please the court. My name is John Brolier. I represent the App.No SUMA Health System, the administrator of Brenan Seiler's estate. I'd like to pick up, if I may, with the question that Judge Callahan had with counsel as to the hypothetical if Brenan had assaulted someone, why wouldn't that assault victim have had to timely have presented his or her claim against Brennan's estate within 6 months? Sure, that's good as far as it goes. The really critical element in our case that distinguishes it from all of the car crash cases and the hypothetical assault case are that in the assault example, there was not some pre-existing contract between the assault victim and insurance company that required the assault victim to first exhaust all of their claims with the insurance company. And that's exactly what we have here. I think it's disingenuous to wholly ignore or set aside the contractual scheme that bound SUMA's hands not to pursue the patient. And
okay,
that matter
I have a question for you on that matter.
Sure.
You know, speaking of contracts, I can't remember a time when I had hospital medical treatment anywhere where I didn't basically have to sign off and say, yes, if my health care insurance didn't cover, I'm responsible. I believe, my understanding is that this gentleman was unresponsive when he went in. I don't know if I'm correct about that or not, but that's kind of what I gleaned from the briefs. Was there any such document signed by anyone on his behalf?
Yes, Your Honor. I don't know that it's contained in the probate court record, but I can represent to the court that I think it was a healthcare professional, probably a nurse, who signed an assignment of benefits, essentially on behalf of the unresponsive patient. Now, I'll tell you that in SUMA's attempts to receive reimbursement from the Western Reserve plan, they were told, well, your nurse signed that, so that's not an effective assignment. So again, we're back in the situation where at every stage, Western Reserve has denied the claim, presented and invited opportunities for appeal, dragged its feet, and then only at the end of the line issued a final denial. And it was only at that time that SUMA's contract right accrued against Brennan's estate. The plan document itself, promulgated by Western Reserve, required healthcare providers like SUMA to pursue only the health plan for reimbursement. SUMA's facility contract with Anthem, through which Western Reserve's beneficiaries access advantageous SUMA pricing also bound SUMA's hands only to pursue the health plan. And it's not that they had two equally viable opportunities for compensation as a result of the care provided to Brenan. It was rather a single track, and that track is first, exhaust all of the opportunities for reimbursement from the plan, and only when that denial is final does the claim upon the estate accrue. And that's borne out by practical experience. Every time an unresponsive patient dies, hospitals do not and should not have to engage in a race to the courthouse to open a probate estate in the unlikely event that the health plan eventually denies coverage. Judge Stormer made that very point in page 5 or 6 of her decision, saying that to accept Western Reserve's argument would encourage insurers simply to wait to deny coverage, with or without grounds, until the opportunity to present a claim on an estate has passed. To adopt Western Reserve's reasoning would invite health plans to wait for 6 months and a day, invite appeals, consider those appeals, drag their feet, and then deny them. And so the only way that hospitals could protect themselves in every instance where an uninsured, or rather where an unresponsive but insured patient dies, is to run to the courthouse and open an estate. I don't think that's what the statutes require. The legislature has permitted contingent claims, and the case law reveals that contingent claims may accrue because of an overlaying filter or because of an overlaying contractual scheme. We know that in the Priestman case, which had to do with the brokerage fee that was due to a real estate broker who eventually a lessee had exercised their option to purchase property, that triggered the obligation of the decedent's estate to pay the broker commission. So again, there was always this potential that the lessee or the tenant in that case could have exercised their option, but only until they exercised the option did that trigger the accrual of the claim upon the estate.
Well, counsel, let me ask you this, please. Excuse me. You've used a couple of different words here. You were bound basically by the contract with Western Reserve to go through their avenues to pursue the claim. Isn't there a difference between pursuing a claim and presenting the claim, which basically is just meant to put the estate on notice?
Well, I think the difference is that assuming that the probate court's treatment of this claim would have been consistent with the ultimate decision, I think that the estate administrator would have properly disallowed that claim had it been presented to the estate before it had accrued. So I think we'd.
Wouldn't you argue that? But the debt was owed on the day he died. You knew what the amount total was at that time.
Well, the interesting thing is that we didn't know the amount total because gross claims get submitted to the Western Reserve plan or their third-party administrator, and then there's actually a negotiated rate that they would have been paid or not paid, and until there were repeated appeals, but they had to present medical records, explain everything. So it would have been improper, both violative of the contract and uncertain as to what amount to seek from Brenan's estate, and it would have been premature to have tried to perfect that until SUMA even knew what the final determination of the health plan was going to be. In other words, it would.
Well, again, if you put them on notice of the gross amount and subsequently sought a lesser amount based upon what was negotiated, I guess I go back to the question, and Judge Schaefer kind of rolled a hypothetical into that, or not a hypothetical, but isn't it about notice? Isn't it about putting the estate on notice?
Yeah, I think the estate could have been put on notice, but there wasn't an administrator. SUMA would have had to go through the same rigmarole, and there would not have been any, I guess it would be putting the estate on notice of an unaccrued claim. The contingent claim statute says that you may present the contingent claim within 2 months of it accruing. So SUMA's position is that the claim didn't accrue until after the Western Reserve plan denied. And so it would have been premature to put them on notice because it would be the equivalent of saying, we may or may not have a claim, it hasn't accrued. That's why you wait until the claim accrues in order to then timely present it within 2 months under 211737. I think to say that everyone who has not yet had a claim accrue must still run to get to the courthouse within 6 months kind of ignores the statutory framework that the contingent claim statute permits. You know, there's a reason that contingency is permitted in the statute. And again, you know, SUMA's hands were bound if they had first pursued the estate without having exhausted the plan's provisions, which it was required to follow by its Anthem agreement. That would have been premature and improper, and that claim would have been properly denied by the estate. And we know that from the probate court's decision. So if it
Well, hang on for a second. Right. Hang on for a second. You know that from the probate court's decision. I agree with you. Do you know that from anywhere in case law?
I think that if the health insurance scheme had resulted in a good court of appeals decision, we probably wouldn't be here now. So I think that this factual framework is unique based on my research, and since we haven't seen it in the briefs, everyone's research. I think what we do know is that the court can look to a contractual overlay that ties a party's hands to say, your claim can't accrue until certain other unknown future events happen. That's what happened here. Western Reserve had a track record of paying for drug and alcohol rehab for Brenan, and they'd done that repeatedly in the years preceding his death. They paid SUMA for his drug and alcohol treatment. The only difference in this case is that the bill was about 10 times higher. That's the only reason we can figure out that it was denied here. And then when they denied it...
I'm sorry, quick question. Was this, did Western Reserve deny payment of anything on this bill from day one, the first presentment?
It was denied, and they initially requested medical records. I think that often happens particularly with high dollar claims. They wanted to see the chart, the medical record, and then ultimately it was denied. Then I think in September, in a decision that basically said we have an illegal acts exclusion because Brenan was using both alcohol and illegal drugs. Western Reserve denied the claim at that time, but in that very denial, it invited a second level appeal. SUMA timely availed itself of that second level appeal, and then Western Reserve never issued a response to the second level appeal, prompting eventually SUMA to try and ask for federal external review. So to the extent that there's what's been called a delay here, that was very much of the plan's making. And one could imagine a scenario where a health plan could drag its feet out and try to basically leave the healthcare provider holding the bag. You know, that the Western Reserve Plan had repeatedly covered this kind of treatment for Brenan, that it had invited the appeal, that SUMA was bound to follow that appeal and avail itself of that, and only pursue the patient after the plan denied the claim. All of that means that SUMA's claim on the estate only accrued on April 23rd, 2019, at the end of the road with the plan. You know, the other contract case that deals with presentment that's worth noting is Carter versus Bank One, that dealt with a letter of credit that was only called upon after the decedent had died. Again, an event after death that triggers a contractual right was held to be contingent and timely presented. Likewise, the Kiefer case dealt with a surety note that was meant to cover a deficiency on a mortgage. Again, an event that could accrue after the death of the decedent because of an unanticipated, or if not unanticipated, uncertain future event. That's what we have here. It was uncertain until the end of the line how Western Reserve would handle the appeals that it had invited SUMA to make.
Counsel?
And if we want,
Counsel,
yes.
I don't know that this makes a whole lot of difference, but I am curious. The first time the claim was denied, was that within 6 months of the date of the death?
Yes, it was, Your Honor, but that first denial expressly said, hey, send us I'm paraphrasing, send us the patient's medical record. So it was hey, you sent us a $341,000 bill, why don't you give us some backup? And I gather, not being a reimbursement expert myself, but I gather that's pretty customary, that the insurance company will say, send us the record. They have nurses on staff who will review it. I think then they see this, it's drug and alcohol toxicity, that prompts them to do the denial. The denial invites an appeal and makes provision for a second level appeal. So there's the plan itself and in its actions contemplate this kind of a dialogue or administrative appeal. And if we'd flown off the handle and sued them ahead of time, why then they'd be saying you didn't exhaust your administrative remedies. So we're a bit betwixt and between if it's not proper to wait until the final denial for the contract claim to accrue.
But you could have pursued the administrative appeals while the probate estate was open, though, right? To get to a final amount at some point in the future?
I think that the fiduciary of the estate would have had to disallow any such premature claim. If my client's the administrator of the estate, so if the healthcare provider presents this premature unaccrued claim to the estate, I think it would be properly denied.
Just so you know, you got 50 seconds.
Okay, well, I'd be happy to respond to any further questions given the limited amount of time, if I may. I think we've made our position pretty clear in our briefs and our arguments. I'm happy to respond to questions. It looks like the court's satisfied.
Anything? Okay. Thank you very much. 4 minutes and 8 seconds.
Thank you, Your Honor. I will be brief. To his first point about the facility agreement with Anthem, two responses to that. One, it's a private contract, and it's our position that a private contract that SUMA enters into with Anthem does not nullify or really impact at all their statutory requirements under the presentment scheme. And secondly, they could have done both. And I think it's important to note that SUMA could have done both. And best case scenario, as was brought up during Attorney Brolier's argument, after the first denial, when SUMA knew that they likely would not get coverage, or at least would be fighting about coverage, they could have presented their claim against the estate. And the statute merely requires that you do that by a writing. So put in writing that this liability exists and put the estate on notice. And it's our position that that's what SUMA should have done at the outset or at that juncture. As to same with the race to the courthouse argument, it's our position that that concern doesn't necessarily translate to the real world as a real problem. With all respect to the trial court, I do believe that SUMA's statutory requirement to present a writing to the estate, to let the estate know about the liability, is not overly burdensome. At most, maybe, to Attorney Brolier's point, could be an inconvenience, but it is a statutory requirement, and that's what the legislature intended. And lastly, as to accrual of the claim, the term accrue has well-established legal significance. And as we point out in our brief, the accrual of a cause of action is about when the events giving rise to that claim occurred. It's our position that the rendering of the medical services was the event that gave rise to the unpaid medical bill. And that's when the claim accrued. The Bickham case is a case that we cite that specifically deals with accrual of a claim for services. Again, it is analogous because we don't have a case on point, Your Honor. But in that case, it's a claim for unpaid guardian and attorney's fees. And that court specifically analyzed the question of when the claim accrued. And the accrual of that cause of action was at the time the services, the guardian services and the attorney services, were rendered. And we draw an analogy using that Bickham case to SUMA's claim because, for the same reasons, the event giving rise had occurred. I do think lastly, SUMA would like this court to do is to essentially use the contingent claim exception as a catch-all, but that's not what it was intended to be. It was drafted very narrowly with terms that have well-established legal significance, like cause of action, like accrue, and subsequent to the decedent's death and or the presentment period. That 6-month period was created for good policy reasons, and even policy aside, Ohio courts have established that these requirements should be strictly applied. And so we also rest on our briefs, and we would like this court to reverse the trial court's decision, enter judgment in favor of Western Reserve Hospital and the plan, and order that SUMA's claim against the estate was untimely and it is forever barred under the terms of the statute. No payment shall be made on that estate, and no action shall be maintained on that claim.
All right. Excuse me. Thank you both for very good and interesting arguments. We will take the matter under advisement. We will issue a written decision in due course. It will be mailed to both sides as well as posted on our website and the website of the Supreme Court of Ohio. Our next oral argument will be next Tuesday, October 27th. Everyone have a good day. And again, thank you very much.
Thank you, Your Honors. Thank you.
Thank you.
Thank you, everyone.